Good morning to one and all present here. Myself Harshita, and my today's topic is right to guardianship of women under personal laws. As you already know, what do you mean by guardian in your school days and college days? Now let me briefly give the introduction of guardianship. Uh, guardian is a person who is primarily responsible for a child's health needs, education, and other essential needs. Usually, a father is a natural guardian. In his absence or at his death, the mother becomes the guardian of the child. No other person except mother and father can be natural guardian of the child. Guardianship is established when a person other than the child's father and mother has legal custody of the child. A guardian has control over the person and he has right to take all decisions related to the person. The guardian is legally responsible for the child's all needs and essentials. The term guardianship is used when the legal custody of the person is with someone other than the child's mother and father. Guardianship is applicable for a minor child who has not attained 18 years of age because a minor is physically and intellectually imperfect and immature and therefore needs the care, attention, and protection of any other persons. Uh, a guardian may be natural, testamentary, or appointed by the court. Other than these, there are other two types, that is guardianship of affinity and de facto guardian. The three distinct legal systems, personal laws are relevant. That is Hindu law, Muslim law, and the Guardianship Rights Act, and Christian law. Parsi law is applicable, but we are not going depth into it. Important legislations regarding guardianship are Hindu Minority Guardianship Act and Guardians Ward Acts. Guardianship under Hindu law. The Hindu law relating to guardianship of a person is the Hindu Minority and Guardianship Act 1956. According to Section 4 Sub A of the Act, a minor is a person who has not attained the age of 18. And according to Section 4 Sub B of the Act, a guardian is a person who is responsible for the care of the child or the child's property or both. The section further states the different types of guardians, that is natural guardian, testamentary guardian, guardian appointed by the court. Other than the three above mentioned guardians, there are two other types. They are de facto guardian and guardians by affinity. Natural guardian. According to the Section 6 of the Hindu Minority and Guardianship Act 1956, only three persons are considered as natural guardians, that is mother, father, and husband. Section 19 of the Guardians and Wards Act 1890 states that a father or a husband of a minor child or a minor wife, respectively, cannot be deprived of their natural guardianship unless the court finds them unfit to take care of the minor child or wife. Section 13 of the Hindu Minority and Guardianship Act 1956 states that the welfare of a minor child is the most essential, and if the court is of opinion that guardianship of any person will not be for the welfare of the child, then the court can remove him from being the guardian of that child. According to Section 6 Sub B of Hindu Minority and Guardianship Act 1956, the natural guardian of the minor illegitimate children is the mother, even though the father is alive. In case of the adopted son under Section 7, the natural guardianship is passed on the adoptive father and after his death to the adoptive mother. In case of legitimate child, that is educated child, mother can become a guardian only after the death of the father or upon his incapability to become a guardian. Let us move on to the case relating to natural guardianship of Hindu Minority Act. That is, in Geeta Hariharan versus Reserve Bank of India, and Vandana Shiva versus Jayant Bandyopadhyay. The Supreme Court has held under certain circumstances, even when the father is alive, mother can act as a natural guardian. The term after, used in section 6 sub A, has been interpreted as in absence of, instead after the lifetime. Rights of guardian of a person. The natural guardian has the following rights in respect of minor child: right to custody, right to determine the religion of children, right to control movement, right to reasonable chastisement. These rights are conferred on the guardians in the interest of the minor children, and therefore each of these rights is subject to the welfare of the minor children. The natural guardians have also the obligation to maintain their minor children. Next is testamentary guardians. Testamentary refers to appointed through the will. That is a guardian who is appointed through a will. A testamentary guardian of a Hindu law. A testamentary guardian is the guardian appointed by a natural guardian through a will. Under section 9 of subclass 1, a father has the testamentary power of appointing.
Harshita, your voice automatically came down. That is one thing. Then you take care of your slides also. There should be compatibility between your explanation and the slides exhibiting. What happened to you? That voice is not that much audible.
Okay, sir. A testamentary guardian is a guardian appointed by a natural guardian through a will. Under section 9 of subclass 1, a natural guardian is and a father has the testamentary power of appointing a natural for his legitimate children, that is educated children, on his property or both. But section 9 subclass 2 states that if mother is alive after the death of the father, then she will be the guardian of the children, and the will made by the father would remain ineffective. It will be revived only if the mother dies without appointing a guardian by will. Section 9 sub 4 empowers the mother of the illegitimate children to appoint a guardian for the children, property or both. In the case of minor girl, the guardianship shall terminate at her marriage, and that would not revive even if she becomes a widow while being a minor. The person appointed as testamentary guardian shall accept the minor. The person appointed as a testamentary guardian shall accept the guardianship expressly or impliedly. He can refuse to be the guardian, then he cannot refuse as resign from being the guardian except with the permission of the court. Next is guardians appointed by the court. Under Hindu law, the court can appoint a guardian to a child under the Guardians and Wards Act 1890, which would be called a certified guardian. The powers of the certified guardian are also stated in the Act. The Act confers power to district courts. A district court can appoint any person as the guardian of a child if it thinks necessary for the welfare of the child. The Act states that while appointing the guardian of a child, the court must consider the child's sex, age, parents' wish, and the personal law of the child. The Act considers that the welfare of the child is of paramount consideration, and any decision taken by the court should be for the welfare of the child. High courts have an inherent power to appoint a guardian to a child, undivided interest in a co-parencer or his separate property, but his power is rarely used by the high courts. Next is de facto guardian. The term de facto guardian is not mentioned anywhere in any law, but it has always been recognized by the court. A de facto guardian is a person who has taken a continuous interest in taking care of or managing the child, or his or her property, or both property and the person. A de facto guardian is not so a legal guardian, and therefore legally he has no power over the child or the property of the child. But he has assumed and takes care of the child and the property. A de facto guardian is not made by a single or few acts, but there must be a continuous course of conduct over the child's property. Next is guardianship by affinity. Uh, Guardianship by affinity is the guardianship of a minor widow by a person in relation with the husband within the degree of sapinda. Sapinda means cousin marriage in Hinduism. Uh, Father-in-law can be guardian by affinity, but Section 13 of Hindu Minority and Guardianship Act states that the welfare of the child must be paramount, that is, having supreme power consideration. Therefore, it is necessary to check whether the minor widow would be safe and her needs would be fulfilled by the guardian by affinity. Next is guardianship under Muslim law. Guardianship under Muslim law is also known as hizanat in Muslim law. The law of guardianship in Muslims came from certain verses in the Quran and a few hadiths, that is, news or stories. Under Muslim law, there are only three types of guardians, that is, natural guardian, custody, and de facto guardianship. Classification of guardianship in Muslim law fall under the following three categories: a testamentary guardianship, guardians appointed by the court. Natural guardian. The natural guardian of a child under Muslim law is considered to be the only father, and the mother is not considered as the natural guardian or the other guardian even after the death of the father. The father is considered to be the only guardian of the child, even if the custody of the child is not with him. Even then, he has control over all the decisions relating to the child. In Imbandi versus Mutsaddi case of 1918, the court held that till the father is alive, he is the sole and supreme guardian of his minor children. The guardianship of the father is only upon his legitimate children. He has no guardianship and entitlement upon the illegitimate children, that is, uneducated children. A Muslim mother can have custody of the children, but she cannot be the guardian of the children. In Sunnis, the father is the natural guardian of a child, and after the death of the father, the guardianship is passed to the executor. In Shias, the natural guardian is the father, but after the death of the father, the guardianship is passed to the grandfather, if alive. If the grandfather is alive, then the guardianship will be vested upon, even though the father has appointed as an executor, the guardianship will be passed to the grandfather. The executor would become the guardian only in the absence or after the death of the grandfather. If the grandfather, before his death, appoints an executor, then after the death of the grandfather, the executor appointed by the grandfather would become the guardian. Next is testamentary guardian. A testamentary guardian is also known as wali, guardian, amin, or khaim mukam. In both Shia and Sunni, the testamentary guardian can be appointed by the father. In Sunnis, in the absence of in absence of father, sir, network problems.
You are audible. Go on. What is the problem? You are audible.
Yes, sir. in Sunnis, in the absence of father, the guardianship would be to a general executrix by the will of the child's father. That she can mother can appoint a testamentary guardian for her property of her minor children. First, when she has been appointed a general executrix by the will of the child's father, she can appoint an executor by her will. Secondly, she can appoint an executor in respect of her own property, which will devolve after her death on her children. Next is guardian appointed by the court. On the failure of natural guardian, guardians and testamentaries, the Qazi was entrusted with the power of appointment of guardian of a Muslim minor. Now the matter is governed by the Guardians and Wards Act 1890. This act applies to the appointment of guardian of all minors belonging to any community. The High Courts also have inherent powers of appointment of guardians, through the power is exercised very sparingly. Under the Guardians and Wards Act 1890, the power of appointing or declaring any person as guardian is conferred on the district court. The district court may appoint or declare any person as a guardian of a minor child's person as well as property whenever it considers it necessary. For the welfare of the minor, taking into consideration the age, sex, wishes of the child as well as the wishes of the parents and the personal law of the minor.
Not audible. Harshita, whether you are speaking or what?
Next is guardianship under Christian law. The Guardians and Wards Act 1890, which resides in the secular realm, also may be resorted. The relevant provisions are refused herein. According to the section 17 of the above said, the matters of case should be considered by the court appointing the guardian. That is, the section reads, first, in appointing or declaring the guardian of a minor, the court shall, subject to the provisions of this section, be guided by what consistently with the law to which minor is subject appears in the circumstance to be for the welfare of the minor. In considering what will be the welfare for the children, the court shall have regard to the age, sex, and religion of the minor, the character and capacity of the proposed guardian, and seeing his current financial position and his nearness of kin to the minor. The wishes, if any of the deceased parent and any existing or previous relations of the proposed guardian with the minor or his property. If the minor is old enough to form an intelligent preference, the court may consider that preference and make him as a guardian of that particular child. Section 19, Christian law involves Section 19, which prohibits the court from appointing guardians in certain cases. And Section 24, that is duties of guardian of the person. A guardian of a person of a ward is charged with the custody of the ward and must look to his support, health, and education, and such other matters as the law to which the ward is subject requires. And Section 25, that is title of the guardian to custody of ward. The first is, if a ward lives or is removed from the custody of the guardian of his person, the court, if it is of opinion that it will be for the welfare of the ward to return the custody of his guardian, may make an order for his return, and for the purpose of enforcing the order may cause the ward to be arrested and to be delivered into the custody of guardian. Then second is, for the purpose of arresting the ward, the court may exercise the power of conferred on a magistrate of the first class by Section 100 of the Code of Criminal Procedure 1882. Then third is, the residence of a ward against the will of his guardian is not by his itself, and the guardian is not appointed. Then the case which comes here is 30 Hoshi Dholikuka versus Hoshiam Shavaska Dholikuka. The court held the principles of law in relation to the custody of the minor appear to be well established. It is well settled that uh, any matter concerning a minor has to be considered and decided only from the point of view of the welfare and interest of the minor. In dealing with the matter concerning a minor, the court has a special responsibility, and it is the duty of the court to consider the welfare of the minor to protect the minor's interest. In considering the question of custody of a minor, the court has to be by the only consideration of the welfare of the minor. It is, however, noteworthy that under Indian Divorce Act, the sons of Indian fathers cease to be minors on attaining the age of 16 years, and their daughters cease to be the minors on attaining the age of 18 years. Then comes Hindu Minority and Guardianship Act 1956. That is, this act may be called as Hindu Minority and Guardianship Act 1956. It extends to the whole of India except the state of Jammu Kashmir and applies to Hindus domiciled in the territories to which this act extends, who are outside the territories. Act to be supplemented to Act 8 of 1890. The provisions of this act shall be in addition to and not save as in hereinafter expressly provided in derogation of the Guardians and Wards Act 1890. Application of this act. This act applies to any person who is Hindu.
Why you are explaining that act here? Harshita, why you are explaining that here?
Sir,
so
in PPT it is not involved.
So the very first topic that was on Hindu law. Then you explained Muslim law.
Sir.
Then you explained Christian. So then why you are explaining that Hindu Minority and Guardianship Act?
Like
whatever to be explained for that, you should have explained those things while explaining Hindu law, isn't it?
Yes, sir.
So why again you are moving on to the topic once you completed that Hindu law?
Sir, I thought explaining it separately, sir.
Again you are, so while explaining Hindu law only you have to explain that.
Okay, sir.
After explaining all these Hindu, Muslim and Christian law, again explaining Hindu law, saying that the provisions, they are not elaborately explained. So that is not fair. That is not a way to present the paper. So while explaining Hindu law, there only you could have explained this legislation. Okay. Don't explain all those things. What is there for this? After this act, what is that you are going to explain? So I think you are left with
no, nothing.
Okay, you go to conclusion.
Conclusion, sir.
Yeah, go to conclusion.
Conclusion. A child is the future of the country, and therefore it is very important that the child should be in a good environment where he is treated and nurtured properly. A minor child is incapable to take care of himself or take decisions. There is a need to have a person to take care of the child, support, love, and provide all the basic requirements to the child. Therefore, the guardian of a child should be such a person who takes proper care of the child. The main consideration while appointing the guardian should be the welfare of the child. It is the time to recognize both father and mother as equal guardian, as done in the case of adoption through the personal laws. Amendment Act 2010. Thank you. Sir, done.
No, you are telling like there is no such kind of equality so far as guardianship rights are concerned under present law, isn't
Yes,
it?
sir.
So you are telling like there is no equality. Is there any discrimination in terms of father and mother while taking a particular while exercising that guardianship right over child? Are there any
Yes, sir.
discrimination?
Like in Hindu law,
Ah, in the,
yes, sir. In Hindu law, the guardianship of father is accepted, sir. But in Muslim law, uh, uh, like only father is the soul and
yes, yes. So father,
soul of the
forefather.
family.
So
So
father. Okay. So in Muslim law,
no other no other person is accepted as guardianship if the father is alive. But in other laws, it is accepted if the father is alive also, sir.
what is that Hindu law? So you are telling like natural guardian is only father, or what is the status of that guardianship in case of death of father?
Natural. In Hindu law, natural guardianship is mother or father, sir. But in absence of mother and father, an uh, appointed executor may take care of the guardian.
Testamentary guardian. So what is the
Yes, sir.
what is the testamentary guardian? What do you mean by the testamentary guardian?
Testamentary guardian means appointed through a will, sir. A person who is appointed through a will. Uh,
Uh, who will be executing that will?
like father, sir, or
Father.
court, sir.
Okay, okay.
In
So in,
absence of father or mother, court will be handling these all cases.
good. So in case of illegitimate child,
Yes, sir.
guardian,
Yes, sir.
illegitimate child, who will
Yes,
be
sir.
illegitimate child means the child born out of illegal marriage or a kind of
Who is not educated?
yeah, sorry.